All rise.
All rise.
President, the judges of the Supreme Court of Justice.
Please take your seats. Caribbean Court of Justice, Appellate Jurisdiction. On appeal from the Court of Appeal of Guyana, the following four matters are called for post-judgment hearing for consequential orders and costs. They are as follows. CCJ Appeal number 7 of 2019 between Zulfikar Mustafa versus the Attorney General of Guyana and the Chairman of the Guyana Elections Commission. CCJ Appeal number 9 of 2019 between Christopher Ram versus the Attorney General of Guyana, the Leader of the Opposition, and Joseph Harmon. CCJ Appeal number 10 of 2019 between Bharat Jagdev versus the Attorney General of Guyana, Dr. Barton Scotland, and Joseph Harmon. CCJ Appeal number 11 of 2019 between Charandas Prasad versus Compton Herbert Reed, Dr. Barton Scotland, the Attorney General of Guyana, Bharat Jagdev, and Joseph Harmon. Can we have the appearances for the court, please? Thank you.
If it pleases Your Honor, good afternoon. I am Sanjay Dattadin. With me is Mr. Stephen Singh and Mr. Ganesh Gupta, and we appear for Mr. Charandas Prasad.
Pleases you, my lords. Mr. Douglas Mendez leads me, Mr. Devish Maraj, and Mr. Mohbir Andil Nandalal, Mr. Manoj Narayan, Mr. Chandra Patish Shaltram, Ms. Marcia Nadi Sharma, and we instructed by Ms. Candace Barrett for the Leader of the Opposition in all matters. All matters.
May it please Your Honor, Kamal Ramkran for the appellant Christopher Ram with Mr. Devendra Kisun.
Your Honor's Amon Courtney for the Attorney General of Guyana in the no confidence motion appeals. I appear with the Honorable Attorney General, Mr. Basil Williams, Senior Counsel.
Your Honor's my lords, and we are also appearing for Zulfikar Mustafa in that matter. The leader of the opposition is not in that matter. My apologies.
If it please Your Honor.
I appear on behalf of the Guyana Elections Commission, the added respondent.
May it please Your Honors, the Attorney General appears in person and in association with Attorneys Ralph Thorpe and Mr. Hal Pollock QC.
If it pleases Your Honor, Mr. Rex McKay lead myself and Mr. Robert Corbin for Compton Reed.
It please Your Honors, Tini Husti in association with Mr. Rafi Khan, Senior Counsel for Respondent Dr. Barton Scott.
Good afternoon, may it please Your Honors, Roy Stilford appearing for the Respondent Joseph Harmon.
Yes, well, thank you very much, Counsel, and good afternoon to you all. We had set today in the hope that Counsel, particularly for the Attorney General and the Attorney General, and Counsel for the Leader of the Opposition might be able to report to us on whether there has been any consensus in relation to issues surrounding the conclusions that we arrived at on the two cases, in particular the no confidence case, where we ruled that the no confidence vote that was held was validly passed, and in relation to the GCOM chairman case, So I believe that it would be useful to hear both from Mr. Mendez and Mr. Courtney.
Good afternoon, Your Honors. The short answer to your question is that we were not able to reach consensus on consequential orders in any of the matters that are currently before you. And I think I have Mr. Courtney's consent to say so on his behalf.
Okay. And what is the proposal of the leader of the opposition for the way forward?
Well, we would propose to suggest to the court the orders that would flow from the findings that you made in both matters in order to provide appropriate redress, in order to bring the matters back on track, as it were.
Okay, in relation to the no confidence motion matter, the Constitution, as I had said earlier, prescribes what should happen in Section 106.
Yes.
In relation to the GCOM case, by concluding that the procedure was flawed and in breach of the Constitution, the inexorable result, unless that result is somehow stayed, is that there isn't a GCOM chairman, and that process has to be re-engaged. Is it possible or tenable that there can be elections within 3 months without a chairman of the Elections Commission?
The answer to that is yes, Your Honors. One of the issues that has arisen, I can say broadly speaking, is as to what list is to be used. And we respectfully submit that the law is very clear on that question. And therefore, there is no discretion or no decision to be made by anyone as to what list is to be used. And that is really the only outstanding issue, as it were.
When you say what list is to be used, what
list of voters?
I know. Yes. Oh, what list of voters?
Yes. Oh. This is voters for the election.
Right.
Yes. The other list, which is a list of 6 persons, not unacceptable. That's another list altogether. No, not that list. No. If there was no disagreement on that, then we'll be home clear as far as that is concerned. But I imagine that will still be contentious.
So your client suggests that the elections that must occur should occur on whatever list is best available at this point in time.
Well, the position that my client takes is, first of all, that an election ought to have been held by the 21st of March for the latest, there having been no vote by the Assembly to extend the time. So that ought to have been the position, but for the decision of the Court of Appeal, which is now overturned. And therefore, in fact, it turns out that there was a list in existence as of that date. The last official list of electors, referred to as the OLE, was a list prepared with a qualifying date of the 30th of October 2018. The relevant provisions of the election laws provides that...
October when?
October 30th, 2018. That was the last list that was provided. I could take you through the various provisions, but this is in summary the position of the Leader of the Opposition. So that list exists, and in fact it was used in the local government elections in 2018. That list, to use a phrase that is probably not entirely accurate, expired on the 30th of April. Expired meaning that it was, as of the 30th of April, it was now available to be added to and subtracted from on the basis of persons who became qualified or persons who ceased to be qualified, as the case may be. But the way the law operates, as we understand it, is that the list prepared as of the qualifying date of the 30th of October 2018 is the list to be used for whatever purposes become necessary over the next 6-month period. So for that 6-month period, October to 30th of April 2019, if there was an election, that would be the list to be used. And we say that the election ought to have been held on the 21st of March, and therefore that is the list that is available to be used. If not, then it is just a matter of using that list in accordance with the same provision, Section 7(1) of the Elections Amendment Act, and you supplement the list with any additions that would have taken place since the 30th of April to the date of the election and any deletions. So you say the law is very clear as far as that is concerned. But if the intention of the court is to bring us back to the position where we ought to have been, but for the decision of the Court of Appeal, then an election ought to have been held on the 21st of March with the list then in existence, and it's a matter of the court now fixing a date by which the elections are to be held. Strictly speaking, again, because an election ought to have been held by the 21st of March, then this court ought to hold that an election be held within a reasonable time. But the position of the Leader of the Opposition is that that the order should be that an election ought to be held within 3 months of today's date. So we are fully prepared to accept the entire period of 3 months provided by the Constitution in order to bring things back on track. And that would give all of the parties sufficient time to make whatever necessary adjustments there may be, but on the basis of the list in existence on the 21st of March.
And in the interim, the Leader of the Opposition and the President work towards having an election, a chairman of elections.
Yes, and what we, in relation to that, the other matter we're proposing that the order be that the appointment be quashed, but then we are going to ask the court to assist the parties by fixing a timetable during which they are, in accordance with the guidance given by the court, they are to communicate with each other, not excluding a face-to-face meeting, in order to agree a list of 6 persons not unacceptable to the President.
What sort of timetable would be satisfactory to your client?
We were suggesting a period of 7 days.
7 days?
Yes. And then once the list is provided to the President, that the President make a decision within 3 days thereafter, because he would have a list that is not unacceptable to him, and then he makes his decision. So within a relatively short period of time, a chairman would be appointed, and again, the direction of the court is that both parties must act in good faith in order to achieve that result, so that you would have a chairman in place who would be able to preside over any other decisions that have to be made in relation to the election, which must be held.
Yes. Now, those 2 issues we have examined are related, obviously, but we have sort of discussed them separately. In other words, the date for the election, you're saying within 3 months.
Yes.
And secondly, the appointment of the chairman, which you're saying basically within 2 weeks, let's say.
Yes.
But they're not separate, they are conjoined, because at the end of the day, surely it is for the commission to indicate the circumstances where there can be credible elections held in Guyana. Are you saying that we could stipulate 3 months for the holding of elections without hearing from the commission as to whether credible elections can be held within those 3 months?
Well, I'm not entirely certain as to what Your Honor means by a credible election, but the point is
elections in which the people of Guyana have confidence that their will is accurately expressed.
Well, the Constitution, I think, speaks very loud and clear as to what is to happen in these circumstances. It says that an election must be held within 3 months unless the National Assembly extends that period of time. So whatever the state of the list, whatever the state of the commission, it really doesn't matter. The Constitution says that you have a 3-month period within which to hold the election after a vote of no confidence. And it is for the National Assembly in its wisdom to listen to whatever submissions that the Commission may have to make on readiness or non-readiness, as the case may be, in order to decide whether to extend that period of time. So that it falls within the discretion of the President, of course, or anyone, to make such a motion before the National Assembly that the time be extended, and bring to bear all of the considerations that are relevant to that question. It is not really for this court to do that, because you will have to receive evidence from all parties in order to make an assessment as to whether a credible election can be held or not. For the time being, all this court is required to do is to uphold the letter of the Constitution, and doing the best as it could. As I said, in accordance with the Constitution, an election ought already to have been held. And so what you're basically doing at this point in time is seeking to effect restitutio in integrum as best you can, if that is an appropriate concept in this context. But we're basically trying to do our best to comply with the Constitution, having regard to the fact that the 3-month period has in fact already passed. And we are suggesting that the most reasonable way to do it is to direct, in accordance with the Constitution, and the words of the Constitution are there, we don't need to invent any new words, that the election, it says that the President and Cabinet must resign and an election must be held within 3 months. And the government is to continue, again, for the purposes of the holding of the election. And we only need to follow the words of the Constitution itself. We would ask that you give directions in relation to the list, because...
Sorry, which list?
Well, this is the point, because there is
That's the list of electors.
The list of electors. I'm sorry. The list, the OLE, the official list of electors, because there is a controversy raging as to what list is to be used, and Mr. Marcus will address you on that. He has not, and I have not been referred to, I should put it this way, to any provision which gives the Commission the power to delay an election because it considers that it is not ready with a list. I have not been referred to any provision. If the President, under normal circumstances, decides in his discretion to dissolve Parliament and to declare an election, then the Commission must comply. There is no, I have not seen any provision which gives the Commission the power to say to the President that that date is invalid, you must fix another date. Of course, I imagine that the President, in deciding the date of the election, would consult with the Commission.
What about
62.
Article 162.2? Notwithstanding anything to the contrary in this Constitution, if the Elections Commission is satisfied with the holding of an election pursuant to the provisions of paragraph 2 of Article 60 or Article 162 on the day appointed, therefore would be attended by danger or serious hardship, it may, after consultation with the Prime Minister and the Leader of the Opposition, by notice published in the Gazette, postpone the holding of the election to a day specified in the notice. What about that?
Well, if it decides that the necessary preconditions for the exercise of that power exists, then it will do so irrespective of what this court says. But this court cannot fashion an order on the presumption that the Commission is satisfied that the preconditions for that power exist. And I haven't heard it yet in any event said that there is any danger or serious hardship in existence.
Yes,
but in any event, that is a different discussion. That is a different controversy, which may or may not arise.
Yes.
What arises at this stage is what are the consequential orders to be made. This court having held that the vote of no confidence is valid, and doing its best to try and get things back on track, back on the constitutional track. The constitutional track, of course, would also include the Commission's power under Section 162, but it will have to make a decision at a later stage as to whether it will invoke that power or not. And of course, that power, as with all powers, will be subject to challenge in court.
Yes. That's not a warning, I hope.
Well, it is a reminder.
It's a reminder.
It's a reminder that public authorities must exercise their powers within the four corners of any provision that gives them that power. And they can't invent dangers or crises in order to...
But you see, Mr. Mendes, the last challenge took 6 months to be resolved, and that was quick. That the courts of Guyana, as we said in our judgments, have to be congratulated for the speed with which this matter reached us, and we did our best to do it as quickly as we could, so that you can win the battle but lose the war.
Well, Your Honors, all that the court can do is to do its best to uphold the laws it sees it at that point in time, and to make declarations and to give guidance in the expectation that public authorities will follow what you have to say, will follow your interpretation of the law and be guided accordingly. That is the best that can be done. We cannot ask you to make any orders that it's not within your remit to make. And I think that the consequential orders that I'm suggesting you do make would give effect to, if not the letter of the Constitution, at least the spirit of the Constitution, in the particular circumstances that have arisen. What happens afterwards, of course, it is for the relevant public authorities to decide what they are going to do. All I can say is that one hopes, and the court can only hope, that they would comply with the law and not seek to abuse it.
Okay. All right, let's hear from Mr. Marcus.
Much obliged.
Yes, Mr. Marcus, there are two discrete issues. The first, well, not in any particular order, but one is the holding of fresh elections. Our conclusions, in the judgment that we gave on the no confidence motion, lead inexorably to the holding of fresh elections. I think everybody agrees on that. Nobody could disagree that the Constitution states that those fresh elections should be held within a particular time frame. Now, what is GCOM's position on those two issues?
First of all, Your Honors, I'd like to say that I believe that consistent with our obligation to be candid with the court, we ought to have indicated to you that we did not get that opportunity that you gave us to put our heads together. When the adjournment was taken last Tuesday, I understand that we were supposed to see what we could have arranged consensually. And if there was no such agreement, then we'd come back to the court and the court would deal with the matter. The fact is we have not had that opportunity because of the intervention of an awkward long weekend. You had a public holiday Wednesday, public holiday Thursday. Friday was the only working day, and then you had Saturday and Sunday. Now, after the adjournment on Tuesday, my learned friend, Mr. Mendes, indicated to me and to Mr. Courtney that he would be sending us a draft order for which we would have considered and discussed and perhaps make proposals or counter-proposals. That was not forthcoming. For myself, I was waiting that, and when none came, I departed to join my colleagues in Guyana on Thursday to have consultations to discuss the matter. And while I was there, I was communicating with my chambers to ascertain whether that draft order had been obtained. It hadn't arrived. because of that, I decided to put pen to paper and write Mr. Mendez indicating what were the statutory provisions that we felt influenced the holding of the elections. And I know Mr. Mendez has that letter. Coming back now to the obligation of the Commission. The Commission is enjoined by Article 162 of the Constitution to ensure that the elections are conducted in a fair and credible manner and consistent and in accordance with the provisions of the Constitution and of any act. And there are many acts of Parliament, many provisions that govern how the Commission should approach the elections. My learned friend adverted a moment ago to Article 7.1, Section 7.1 of Act 15 of 2000. Now that is an act that provides for house-to-house registration. And there's an act that goes hand in hand with it. Section 2, subsection 3 of, I think it's 1809, which requires house-to-house registrations to be conducted as well.
But Mr. Marcus, all of these acts of Parliament are subsidiary to the Constitution. And if they are inconsistent, if operationalizing them is inconsistent with the terms of the Constitution, then it is the latter that must prevail.
Well, with that proposition of law, I entirely agree, but I disagree that the acts are inconsistent with the Constitution. I suppose it suits the opposition to put a very rigid construction on Section 160, subsection 7, Article 160, subsection 7 of the Constitution. My respectful submission, and I'm prepared to demonstrate that to the court if the court is willing, is that the provision that says the elections must be held within 3 months is directory. It is not compulsory. I propose, if necessary, to refer to the learned authors of Benyon on the interpretation of statutes, which demonstrate to you that there are provisions that are mandatory in one sense, but directory in the other sense of time in particular. And
Okay. Is GCOM able to bind itself, the relevant parties, to a particular outside date?
Realistically, my lord, my honors, no. If I may be permitted to say, you see, GCOM has not been involved in this matter from the commencement, and you do not have all the relevant evidence before you. But I can tell you that from my instructions, GCOM has engaged over 9,000 persons in the field on the operation and has already spent $724 million in the operation. And any other process is going to be longer than the operation in progress. Any other is going to be longer than the operation in progress.
But I'm not sure maybe you're getting there, but I'm not sure I've answered the President's question. He's asking for an outside date.
An outside date?
Yes.
From my consultations, putting everything into place and complying with all the provisions that are necessary, a list would be ready by the 25th of December. December 25. Elections to be held any time after that.
That's a rather unique date, December 25th.
December 25th.
Yes. So you're hoping to provide a Merry Christmas to the electorate of Guyana?
Mr. Marcus, this is disappointing because, as Mr. Mendez says, the Constitution suggests that these elections should have been held sometime in March.
Yes, my lord.
So that you are suggesting an outside date that carries us down 9 more months.
But my lords, if I may be permitted to say, first of all, the elections were not held in March because...
No, I know they weren't held in March. I know, and we're not
I was about to deal
revisiting
with
that.
why. I was about to deal with why. If the parties decided to engage the attention of the courts, and I do not think the allegation has been made, even hinted, that anyone approached the court not in good faith. The parties approached the court to have certain genuine disputes resolved by the court as to the construction of certain provisions in the Constitution. And by that fact, time has been overtaken.
Yes, I think we could accept that.
My
You
Lord,
mentioned the outside date
Yes,
of the
Lord.
25th of December. Is there an inside date? Not really. Is there because that is the maximum.
Not from my instructions,
That's
my
a
Lord.
maximum time that you would need.
My Lord, is something I'd like to say.
Yes.
On the last occasion, I indicated that in my respectful view, the solution lay with the parties getting together, including the National Assembly, which has not been dissolved until the President names a date for elections. The National Assembly continues. And the National Assembly has the authority to extend the time. And if between the President, GCOM advising him as to readiness, and the National Assembly, they put their heads together, they should, if they're acting in good faith, come up with a resolution.
This is a question I perhaps should have asked Mr. Mendez, but are you aware whether the leader of the opposition and the president met since the judgments were given?
Well, not aware, but I have so been told. I have been told that they had a meeting. I can't tell you the details of the meeting, what is the result of the meeting, but I'm told that the president invited the leader of the opposition to a meeting. What is the final result of that, I do not know.
Yeah. Going back to the idea of the inside date,
I'm sorry?
we have a certain number of persons who are conducting the house-to-house registration. What I'm trying to get at is if you continue on that pace, according to your instructions, the list will be ready by Christmas. I'm trying to get from you if the effort was intensified, if more resources were deployed towards the objective, when is the earliest we could have elections?
Well, Lord, what I have indicated to you is the earliest that I have been advised. That is the earliest date, because there's a certain operation that has to begin next month. It is going to run for 3 months. There has to be advertisements. There have to be many other things to be done. The process is all laid out. The Commission is acting according to the requirements of the law, the things laid out in the various acts of Parliament.
But shouldn't the Commission not always be ready to organize this within 3 months? Doesn't that follow from the Constitution? I know it's an ideal situation. We're talking about Guyana, not utopia. But reading the Constitution, is that not a fair conclusion?
Lord, with respect.
Because you're saying, well, it's directory, but I really wonder, what does that mean? I mean, then you speak about 3 months, oh, it's directory. What does that mean? Could be 5, could be 10 months. What does that mean? I mean, there must be some certainty, because as I understand it, whenever you have early elections, not just in Guyana, everywhere, there is a limited period for that, because normally once there is a motion of no confidence carried, then the government, whether they resign or remain, but they will be a caretaker government. So they cannot take the full decisions that they used to be able to take. And that's why in many constitutions there is a limited period that you say, well, we need to get elections done quickly, because we cannot have a government that will be a caretaker government for a year, because important decisions will have to be taken. So whatever the 3 months means, mandatory or directory, it certainly must mean something. And could you then explain to me what it means? If you say it's directory, what does it mean in the terms of
That if
this
there has
Constitution?
not been compliance with the time limit, it does not render what subsequently follows invalid.
So
That's the
the
bottom
parliament that commenced in 2011, that did not run its 5-year course. It was interrupted because the president dissolved that parliament at some point. The elections then were held within a certain number of days, weren't they?
Ordinarily,
90 days.
ordinarily, the elections in this case would have been held around March to May next year. And the commission, in anticipation of that, had proceeded on that basis.
No, but this is my point. The commission, I don't want to say negligent, you know. The commission ought always to be on standby that the president of his own deliberate motion or upon a motion of confidence, which his list loses, renders his government no more. The commission ought always to be on standby that that likelihood could occur. And if and when that likelihood occurs, it is a little strange that the commission could be saying, well, we wouldn't be ready for 90 days. We might be ready for maybe 9 months, maybe a year, and leave the country in limbo for that period of time.
With respect, my lord, the country would not be left in limbo. There is a construction of 1067, with which I do not agree. The construction the provision does not say that the government is a caretaker government or it does not function. It expressly says the government shall continue in office. And I understand that to mean in its literal meaning, the government stays until it goes. That is what 1067 says.
Yeah, but 3 months also has a literal meaning.
Pardon me, my lord?
3 months has also a literal meaning. So we can't just say, okay, well, this I read with a literal meaning, and this I read in a broad sense. There must be some certainty under any constitution. I'm not just talking about Guyana, and I'm not saying that the court is saying that it is a caretaker, but this is normally the case. And under many constitutions, if there is a motion of no confidence and the government has to step down, they will remain, but they will remain as a caretaker government. That is quite normal all over the world. Now, it doesn't say, the Constitution doesn't say so with so many words, but it says with so many words that there will be elections within 3 months.
It also says that the cabinet shall resign.
No, that is 107. That is not 106. That is Article 107.
No, that's 106.
It's 106, not 107. But
Please.
if you were to,
One moment, please, madam. The president.
106.6 speaks about resign.
Yeah.
6, the cabinet includes the president shall resign if the government is defeated.
Yeah.
That's 6.
And then 7
But
speaks
7
about
is
remain.
notwithstanding its defeat. Notwithstanding its defeat, the government shall remain in office
And shall
and
hold
shall
elections.
hold an election within 3 months, as I've
That's exactly what it
in terms of what we're here for now, though, can you reasonably resist the suggestion from Councilman Mendes that the appropriate order we should give should be in the terms of 1067?
And that the court would impose 3 months.
No, we're not imposing anything. Our remit, we're not involved in politics. Our remit is to uphold this document.
Yes, ma'am.
And if it has a clear provision, then what do you want us to do? To ignore it? To reject it? To rewrite it?
No, my lord, but I ask you to give effect to what it says. That same provision contemplates, the framers contemplated that there would be a situation where, though 3 months has been stated, there will not be, for what reason or other, compliance. And it goes on to say...
Where is that? I'm
Would
sorry.
you permit me? It goes on to say, in such circumstances then, when there is no compliance with the 3-month period, well then, the time may be extended by the National Assembly.
By the National Assembly.
By the National
By a
Assembly.
two-thirds majority, so...
This is why
We are not the National Assembly.
This is why I submit that this matter ought to be referred to the National Assembly
We
as
don't
well.
need to refer it. And the National Assembly doesn't need to hear from us to pass a resolution extending the elections to whenever. They don't need for us to direct them on that.
But then, my
Indeed, we
lord,
can't direct the Parliament what to do.
You should give the President, GCOM, and the Assembly the opportunity of getting together and doing what should be done.
But they can't do it.
We
I
had
mean,
hoped that that would have
if you were
happened.
to give the order in terms indicated or suggested by Mr. Mendez, nothing prevents those persons from meeting. And if they were to agree to...
Realistically, my lords, if you state a particular period, it is unlikely that certain contributing parties will adhere to
So you
that.
want us to leave it open-ended? You want us to leave it open-ended and not state a period in which elections must be held?
It wouldn't be open-ended, my lord, if the National Assembly is involved. The National Assembly is composed of persons from all sides, so it will not be open-ended. In fact, there would be room for everyone concerned to state his or her opinion and to make his or her input. It wouldn't be open-ended.
So what is your suggestion in response to, I think, the President's question?
The
What order would you want us to give? Consequential on our decision last
Having
week?
regard to the fact that you had given us an opportunity on Tuesday to have a discussion, to give us that opportunity, we have not had that discussion.
How much time you need for that discussion to take place?
I would perhaps suggest a week, my lord. There's no holiday intervening, and certainly the party should be able to have a discussion within a week to see how this matter could be resolved. That is my suggestion of the cuff.
Okay.
Is that a directory week? I mean, is it flexible or?
My lord, I regret to say that that is the law, and I'm prepared to demonstrate it. I am prepared to demonstrate it, what directory means in this particular
But you're
context.
in practical terms.
I am suggesting a week that we may have a chance
Yes. well,
to
but if-
speak and see what could be done.
Okay, but in practical terms now, when you read this constitution, there should have been an election in March this year. You said that the regular elections would be in March next year. And you're also saying, well, we will have early elections, but not before January.
Listen,
So that doesn't really make much difference or makes it much sense.
The risk, Your Honor, of having election before the time indicated by the Commission is that you will have an election that might not be credible, and we will be back before you on other grounds. On other grounds. What we'll be doing is postponing from now an opportunity to resolve the matter to a later date. Because if there is not compliance with the law and the safeguards that are laid down to ensure that we have a fair, impartial, and credible elections, we may have the position that later on, after the elections are held, with defective lists in particular, as happened before, we'll have to come back to you on other grounds. We'll be back before you on other grounds, because we are aiming at credible elections. Credible, emphasis credible.
Credible but late.
Pardon me, my lord?
Credible but late. I mean,
but tardy.
Tardy.
after the time.
How much time, my lord?
Credible, but tardy is what my learned brother was saying. But Mr. Marcus, let's hear from Mr. Courtney. Let's hear from Mr. Courtney and the Attorney General and
Very well.
submissions.
May it please the court.
Yes, Mr. Courtney.
Your Honors, first of all, may I say that for the Attorney General, I think it is important that before the court makes any directions, that you receive written submissions from the parties. I was under the impression, and I specifically looked back at the video recording for the 10th of May as well as for last week Tuesday to confirm that it was the intention of this court to hear the parties in submissions. In fact, last week, Your Honor, the President specifically resiled from explaining to us what would happen if there was no consensus. And so I
Yes, I recall that, Mr. Courtney, and we did not intend that the, if you want to call it, submissions that we have been eliciting over the last hour or so were intended to displace formally submitted submissions about consequential orders that we may make.
I'm very grateful for that, Mr. President. But let me be brief by saying this. We are dealing with respect with very serious constitutional issues that resound or sound in politics. Your Honors, my learned friend articulates a position, for example, that the cabinet and the president should all resign forthwith. In the same breath, they call for a week to 10 days for a meeting between the president, who has resigned, and the leader of the opposition. It is an impossibility. There are issues about setting a date for an election and whether or not the Caribbean Court of Justice has the power as a matter of constitutional law, respecting the separation of powers, to set a date for an election to be held in the Republic of Guyana. I submit, Your Honors, that great care should be taken before this court displaces what you have repeatedly called the presumption of regularity. That is to say, that governments will obey court orders and do what the law requires, and that it is only in absolutely necessity that this court will issue a coercive order against state parties. So, for example, I fear that if my learned friend Mr. Mendez's articulation is adopted, that is to say, there should be elections by a date certain, it would follow that this court would have to make a coercive order against the president, directing him to dissolve Parliament and to set a date. Now, Your Honors, prior to getting to those issues, it is my respectful submission that the court should receive full submissions from the parties. Secondly, it is my respectful submission that when it comes to a credible election, the experience in Guyana, as was told to this court on the 9th and 10th of May this year, makes it very clear that there is a real risk that if there is not confidence in what happens, that there is a real risk that political parties will rule the day rather than the rule of law. In short, I submit to this court that you should move with all deliberate speed on this highly sensitive, highly political, highly constitutionally fraught issue. I would urge that the week that Mr. Marcos proposed not be dismissed, so that there can be serious discussions between the parties to resolve this, and to resolve it in a way that your Honors may be able to approve an order that the parties are mutually dissatisfied with. I put it that way. Now, I do not underestimate how difficult that is. But my respectful submission to this court is one cannot and should not trivialize the necessity for there to be a list of electors prepared in accordance with law, and anything short of that is a prescription for the commission saying there's a hardship or the language of 162 and that the date has to be postponed, which creates a bigger problem. So I urge caution, I urge deliberation, and I urge an opportunity for the parties to work at a solution.
Mr. Courtney, can you, same question I asked of Mr. Marcus, can you resist the suggestion from Mr. Mendez that an appropriate consequential order from this court, given its decision last week, could be and should be in the terms of Section 106 of the Constitution? If one were to repeat with some adjustments, the wording of 106, would that not be an appropriate consequential order, given our decision?
Your Honor, I would say to you with respect that you would also have to engage 106.7. And I don't want to delay the court any further, but I do wish to draw your attention to 106 and 106.7.
Yes.
106 says the cabinet, etc., should resign.
Yes.
106.7 says, notwithstanding the defeat, the government. There's a question of interpretation there. The government shall remain in office, and if you jump 3 lines to the penultimate, and shall resign after the president takes the oath of office following the election. So the resignation contemplated by 106.7 is after the election. So those 2 sections have to be read together. And it is my respectful submission, and we are prepared to make written submissions, that a country without a president, a country without a prime minister, a country without ministers, a country without a cabinet is something that I would urge the Caribbean Court of Justice not to order, having regard to 106.7, which in my respectful submission clearly contemplates a resignation after the election.
What order would you have us make, aside from the 1 week extension for consultation?
Your Honor, you put me in a very difficult position because the exchange between Mr. Mendez and myself with respect to the orders were and taking a point of departure from His Honor the President on the last occasion when I said that perhaps he should give some directions as to how the orders were to be settled, and said that the court didn't want to be involved in that back and forth, which I understood and respect. What I had put forward to Mr. Mendez, I specifically said was on a without prejudice basis for us to revisit, and I was not expecting to articulate in open court today the position of the Attorney General, and I would ask Your Honor to give me an opportunity to take specific instructions on what we say in public as to what the appropriate order should be. It is a situation, Your Honor, that is not as simple as my learned friends have laid out, and I can give you a very short answer, and I know that will not be satisfactory.
Just one more thing. In relation to the other matter of the appointment of the chairman for GCOM, I know you made a reference to that issue.
We're not hearing you. There's no audio.
Sorry, who is not hearing? Are you hearing now, Guyana?
Mr. Attorney General, are you hearing us?
No, they're not.
It appears no.
Maybe the technician.
Okay, we will have our technician look at this.
And Your Honor, can I just say whilst that is taking place, as you're very well aware, on the Zulfikar matter, I was not involved, so I would hesitate to answer. I would have to yield to the Honorable Attorney General.
Okay.
Yes.
Good.
More than likely.
Okay.
So we need him.
Are you hearing us now, Guyana?
We weren't hearing you for the last 3 to 5 minutes. We were not hearing you.
I see. Okay, but you're hearing us now?
We know you, Your Honor.
Yes. Well, actually, maybe we can hear from you, Mr. Attorney General, on the issues which are being discussed. First of all, can you tell us whether the President and the Leader of the Opposition have met since we delivered judgment in these 2 sets of cases?
Thank you, Your Honor. The President had written the Leader of the Opposition for them to have a meeting on relevant matters connected with these cases. But they have not met as yet. The Leader of the Opposition hasn't indicated, as far from where I sit, he hasn't indicated any time or any response to meet with the President. But hopefully that
Listen, these matters are of the highest constitutional significance, as Mr. Courtney has correctly outlined. And it beats me that the Leader of the Opposition and the President and their respective counsel have not met to discuss the issues that confront us. Everybody says these are important issues, but it seems as though the same degree of urgency and deliberation that are expected of the courts, we don't see them being reflected in the behavior of the political directorate. And that, I think, is unfortunate. This case puts the court in a very awkward position because we don't want to make political decisions. But at the same time, we have to see the rule of law. We feel that it is our remit to assist in seeing the rule of law observed in Guyana. But the observance of the rule of law also requires political actors to conform with the rule of law and to demonstrate a spirit of compromise and reasonableness that allow for the rule of law to take effect. Now, as I said at the outset, everybody knows there has to be fresh elections, and those elections should have been held in March. So when is the earliest can they be held, given a certain amount of give and take on each side? On the one hand, we want as many of the qualified persons who are eligible to vote to be able to vote. That is a constitutional value that has to be upheld. But another constitutional value that has to be upheld is that when there is a vote of confidence that collapses the government, that election should be held within 3 months. So we have to find some compromise between these 2 values. We don't want to impose a compromise. That's not our remit. But it can't be beyond the political directorate to find some compromise there.
Mr. Chief Justice. Hello?
Yes, Mr. Agee.
Yes, sir. Your Honor, I can assure you that His Excellency the President acted forthwith after Tuesday, after the date we last met, and wrote the Leader of the Opposition. So he's awaiting a response from the Leader of the Opposition. But he wrote him forthwith, inviting him to a meeting. Secondly, Your Honor, Mr. Mendes spoke of a list. In fact, that list would be the list from the October 31st qualifying date to the 30th of April. And the law is very clear about that, to add in and delete. The process that the method of doing that is by house-to-house visits. The Act 41 of 2007 amended.
We're not hearing you now, Mr. Attorney General. I don't know if you're hearing us. No, we're not hearing you, sir. I assume our technicians are working on it if they can do something. We would rise for a few minutes.
Rise.
All rise.
President, judges of the Supreme Court of Justice.
Please take your seats.
Yes, Mr. Williams, are you hearing us? Mr. AG?
Yes, please, Your Honor.
Yes.
Yes, please, Your Honor. I was saying, Your Honor, that in Guyana, under our electoral laws, if you wish to create new electors, it has to be by house-to-house visits. If you have to create the National Register of Registrants or Central Register, it has to be by house-to-house visits. And in the case of the list referred to by my learned friend, Mr. Mendez, it has to be done. That list has to be revised by additions and deletions, and that has to be done by house-to-house visits. That really is the law, and that is really caught in the bill of 2007, which is now the Act 41 of 2007. And the explanatory memorandum says this: the thrust of this bill is to provide for the required house-to-house registration for the purpose of all elections, local government elections, and general elections. This is the sole method under our electoral laws that is provided to revise this, to create new electors, or to create the National Register of Registrants / Central Register. So, Your Honor, so that list, that if we want to use the term lapse on April 30th, that would require house-to-house visits to determine who should be added, who should be deleted, because you have deceased persons on the list. You have persons who will no longer be registered and living in the area in which they were previously registered, the registration division. And only house visits could control that situation. So that's our law. But to answer your question, Your Honor, on the order that could be made, bear in mind, again, the question of calling an election date and dissolving Parliament is in the remit of the President of Guyana. The President of Guyana is an executive president of one. So if we look at the question of separation of powers, for example, to propose that someone else gives a date for national elections would collide, unfortunately, with that. If we were to propose the power to dissolve the Parliament to someone else, it would also collide with the Constitution. So therefore, if there's no agreement, for example, to go for the 2/3 resolution, because our view, respectfully, is that those 3 months have been overtaken. Whether they're directory or mandatory, they have been overtaken. And therefore, if we can't get together in the Parliament to get the 2/3 majority, then of necessity, the President being given the power under the Constitution to condemn an election date and to dissolve Parliament should, and this is the order, after consultation with the Elections Commission, dissolve the National Assembly, and general and regional elections shall be held on a date to be fixed by the President under Articles 72 and 601, respectively. Under Article 601, he has the power to name a date. Now, there's no way the President can name a date without being advised by GCOM. That is something that is given. So, having heard what my Lord Senior, Mr. Marcus, has said, it's the question for GCOM. Perhaps GCOM would be in a better position in the week that we have for consultation to be able to update us more, but Your Honors would I don't know if you know this, but when GCOM last advised the President, His Excellency, they wrote him and told him they could hold elections late November. And that was provided that timelines, condition precedent were met, like by materials, training, scrutineers, and the like, and electoral workers. But what happened, and I think this was really a major problem, and I did say that in the hearings in Trinidad. If we had taken up the running after the Court of Appeals order, and GCOM had a quorum, they would have been able to, they would have had an opportunity to resolve all these issues with respect to our source registration. $500 million have been spent already. And we say, with respect, Your Honor, that the commissioners who have been entrusted with the task, such an important task in this country of ours, in the light of our history, cannot be allowed to, but ought not to leave meetings of GCOM so that the business of GCOM cannot go on for lack of quorum. So all these things have really impacted. So we believe, honestly, that one, the President is prepared to get an election date after he's advised by GCOM. He will dissolve Parliament and he will hold the elections. And we must stop saying these things when we know that the law tells us that the President shall remain, the government shall remain. And when you apply the procedure of looking at 1066 or 1067 together, the word notwithstanding gives precedence in 1067 to that of 1066. And so we're saying the President and Cabinet and government should remain, because Justice Witt was recognizing the importance of having a proper government in place. We're a country, we have a border country, sea. We have a long, porous border that transnational crime, everything happens. And we can't protect it normally. We don't have the people to protect it. So at any moment, crises could occur in Guyana. So there are serious problems. And so to say, whilst the government is there to ensure that elections are held in a timely manner, that they should do it on one leg and with a one hand doesn't make sense. So we're saying that the government should remain in place, the President should remain in place with the Cabinet. Moreover, Your Honors, the question of the GCOM chair.
Yes.
The question of the GCOM chair. In consonance with your directions, before the list is formally handed over to the President, in order to facilitate the appointment of a chairman of the Elections Commission, the President and the leader of the opposition shall communicate with each other in good faith, not excluding meeting face-to-face, with a view to agreeing a list of 6 persons who meet the eligibility criteria and who are not unacceptable to the President, from which the President shall select a chairman of GCOM in accordance with the Constitution as expeditiously as possible. And the President shall appoint the chairman from that day so provided as expeditiously as possible. It makes no sense saying that they should do an exercise like that in 7 days, and that the President, after receiving the list formally, must appoint somebody in 3 days. It doesn't make any sense putting in that type of constraint on the two parties. But as I said, we are awaiting word. The President is awaiting word from the leader of the opposition in response to his invitation pursuant to the decision on the 18th of this month that they should communicate or even meet face-to-face. And that invitation is for a face-to-face meeting, Your Honors.
Okay,
so
thank you.
Those are the circumstances in which we find ourselves in. I support the suggestion of Marcus Senior Counsel that we have additional time within which to engage. And I have addressed you in our submissions in Trinidad, and the others are familiar with that. I have been misinterpreted on that, but the situation is one that GCOM has to be a major determinant of the date for elections. And the president is being given the responsibility to name that date and to dissolve parliament, but be allowed to discharge those very important responsibilities under our constitution.
Okay.
Unless you have anything more
Yes,
for me to say.
thank you, Mr. Attorney General.
Are you hearing me?
Yes, I'm hearing you. I've heard you. We've heard you. Thank you very much for your submissions. As Mr. Courtney correctly said, this was never intended to be a hearing where we received submissions on the basis of which. Are you hearing me? No. Okay. We will pause and see if the technicians are able to restore the feed.
Your Honor, if it is not restored shortly and the court is intending to make orders.
No, we're not going to make orders. Well, we are not going to make substantive orders.
That's what I meant. If it's procedural orders, I would undertake to complete if that's what you intended.
Okay, well, that would be helpful. We're going to ask that the parties make written submissions on the orders that the court, the consequential orders that the court can and should make in respect of each of the sets of cases on which judgment was given. We would like those submissions to be made on or before the 1st of July.
Yes, Your Honor.
We don't want overly lengthy submissions. We would restrict the submissions that are being made by Mr. Mendez, Mr. Courtney, by the Honorable Attorney General, to no more than 20 pages. If the other parties wish to make submissions, then they are being limited to no more than 10 pages. We will endeavor to give a decision on or before the 12th of July. Now, between now and the 12th of July, we would encourage the parties, and in particular, the leaders of the lists, His Excellency the President and the Honorable Leader of the Opposition, with their counsel or with their counsel being available to advise them, and the Attorney General being advised as well, or advising himself. We would encourage a meeting or meetings of that nature to take place.
Hello?
Yes, we are hearing you. Are you hearing us?
Go ahead, Mr. President.
Mr. Aki, can you get a message somehow to them that? Okay.
Please issue.
Yes, Mr. Marcus.
May I ask that GCOM be given 20 pages as well?
GCOM can have 20 pages as well.
Very well.
But you see,
the more pages you need, the weaker the case.
Size of font.
we didn't expect single space and a font size of 6 or 8. We expect 1.5 space or even 2 and a font size of at least 12. But you see, Mr. Marcus, that question you asked, because you're the first to ask questions about these submissions, it sends a kind of signal that things may not work out between now and the 12th, and that disappoints me. I am hoping that if and when the parties meet, that they can find some consensus on the way forward. But be that as it may, the court will be open to naturally receiving.
Just going to have problems. They can't bring up security, but not conform to no orders. Are we not hearing them?
Yes, the court will be open to receiving your suggestions as to a consensual way forward. But in the meantime, we would expect to receive submissions just in case that consensus is not arrived at.
Your Honor, may I just make first of all, welcome the opportunity to continue the discussion with my learned friends on the proposed orders. The proposed order was in fact delivered to my learned friend's email address on Friday evening. Apparently didn't see it until sometime on Sunday. But in any event, I need to correct the record as well in relation to the invitation to the Leader of the Opposition. The letter that was sent in was dated the 20th of June. I have it in front of me here on my phone. And it invited him to attend a meeting with the President after the 24th of June. So that meeting obviously has not taken place yet because today is the 24th of June. But certainly my instructions from him is that he is willing and of course anxious to meet with the President in order that these matters could be discussed. The other point that I wish to draw to your attention is that in the Mustafa matter, you have in fact ruled that the appointment of the chairman is unconstitutional.
Mm-hmm.
You have not yet made an order striking out his appointment. And the fact is that he continues to meet and chair meetings since the 18th of June. I do not know what other decisions might be made between now and the 12th of July that may be consequential, but he continues to meet and to preside despite the ruling of this court. I'm just saying that and expressing concern that certainly from the Leader of the Opposition's point of view, and certainly from my client in the appeal, one would have expected that he would have respected what the court has to say concerning his appointment without an order directing him to stand down.
Yes, well, this panel as presently constituted is not going to make a consequential order.
Yes, I appreciate that.
But I appreciate what you have said. So we will adjourn. We will again hope that the Leader of the Opposition and His Excellency the President can meet and can find some consensus, if not on all the issues, on some. But in any event, we would receive your written submissions on or before the 1st, and we will give a decision. We will not give it until the 12th in the hope that leading up to that period of time. Okay. For the benefit of those who are in Guyana, all we've done during the time that you have not been able to hear us is to indicate that we would receive written submissions on the orders that the court can and should make on the 2 sets of cases. And those submissions are to come in on or before the 1st of July. The principal parties, that is to say GCOM, the Leader of the Opposition, The Attorney General are to make their submissions within 20 pages or less, and the other parties within 10 pages or less. The pages are to be spaced, at least 1.5, and the font is to be at least 12. And we expressed the hope that, notwithstanding the order that these submissions be made, that the parties meet and even meet repeatedly with a view, hopefully, to agreeing, if not all, at least such of the issues that are outstanding that we can give a decision on or that need to be made as they can arrive at. So judgment on the submissions will be given on the 12th by the full panel. Yep.
Vote rise.